Welcome to Jurisedge Academy's YouTube channel. In this video, we are going to discuss important weekly legal news from 10th January to 15th January 2022. In first important news, the Supreme Court has held that High Courts should apply their mind while disposing writ petitions under Article 226 of the Constitution. In the case of State of Orissa versus Prasanta Kumar Swain, the Supreme Court has set aside the High Court's judgment and remitted the matter back for fresh decision. The court has held that ex facie there has been no application of mind by the High Court to the grounds of challenge or to the submissions. In fact, the concluding line of the order of the High Court indicates that the decision will not be treated as a precedent. This was an inappropriate manner of disposing of a substantive petition under Article 226, since the High Court is duty-bound to apply its mind to whether the judgment of the tribunal is sustainable on facts and law. In second important news, the Supreme Court has held that cryptic and casual bail orders are liable to be set aside. In the case of Manoj Kumar Khokhar versus State of Rajasthan, the Supreme Court has noted that a bail cannot be granted by cryptic and casual order without considering material aspects. The Supreme Court has observed that while elaborate reasons may not be assigned for grant of bail or an extensive discussion of the merits of the case may not be undertaken by the court considering a bail application, an order dehaws reasoning or bereft of the relevant reasons cannot result in grant of bail. In such a case, the prosecution or the informant has a right to assail the order before a higher forum. In third important news, the Supreme Court has held that right of parents are irrelevant in deciding custody of the child. In the case of Vasudha Sethi versus Kiran V. Bhaskar, the Supreme Court has said that issue of custody of the minor has to be decided on the principle that the welfare of the child is of paramount consideration. In fourth important news, the Supreme Court has held that High Court cannot enter into merits under Section 37 of the Arbitration Act. In the case of Haryana Tourism Limited versus Messrs. Kandhari Beverages Limited, the Supreme Court has held that a High Court cannot enter into merits of claim in an appeal under Section 37 of the Arbitration Act. The court has said that the High Court has entered into the merits of the claim and has decided the appeal under Section 37 of the Arbitration Act as if the High Court was deciding the appeal against a judgment and decree passed by a trial court. Thus, the High Court has exercised a jurisdiction not vested in it under Section 37 of the Act. Lastly, the Supreme Court has held that rules taking away vested rights of employees retrospectively are unconstitutional. In the case of Punjab State Cooperative Agricultural Development Bank Limited versus the Registrar Cooperative Societies, the court has held that an amendment having retrospective application, which takes away a vested right of the employee, would be violative of Articles 14, 16, and 21 of the Constitution. The court has observed that if the employee who had already been promoted or fixed in a particular pay scale, if that is being taken away by the impugned scheme of rules retrospectively, that certainly will take away the vested or accrued right of the incumbent, which may not be permissible and may be violative of Article 14 and 16 of the Constitution. This brings us to the end of our weekly legal update. If you like this video, please like it, share, and subscribe to our YouTube channel.